A very good morning to you and a warm welcome to our program Spotlight. On Spotlight, we usually touch on current affairs related issues and topics. So today we will be speaking about the Prevention of Terrorism Act, and why we would like to touch upon this topic today is because this is most talked about these days. So on Spotlight, we will give you an insight as to what this act is all about, and we will also explain as to why people are speaking about this lately and the amendments made to the act as well. And to do the honors, we have with us President's Counsel and Senior Advisor to the Ministry of Justice, Mr. U.R. De Silva. A warm welcome to the program.
Thank you very much for inviting me, Sharira. And it's a good topic to discuss because we want to clarify the issues here and inform the people who are watching this that we are doing a great service by amending this particular act, and we have to do some more things, but at the moment we are amending the act, so it is our duty to explain it.
Exactly, Mr. De Silva, as you did mention, there were some amendments made, and we will talk about that during the program. But first and foremost, if you can also explain to all our viewers out there in a layman's point of view as to what this act is all about and why did we come up with this and when?
That's a very good question to start with, because why we have normal law available, penal code is there, criminal procedure code is there, evidence ordinance is there. So why we have a special act called Prevention of Terrorism Act? In 1979 latter part, we observed that a lot of Tamil terrorism is coming up, and they were doing a lot of unlawful and illegal activities. To prevent that, at that time, President Jaya Jayawardena, he thought, after consulting with various foreign country people and after going through the laws of those countries, they also having these type of prevention of terrorism acts they are in those countries. So after going through those things, he thought it is fit to have this particular act. That is the very reason in 1979 Act number 48 called Prevention of Terrorism Act came into power. So it was an urgent bill. It went to the Supreme Court, and they have given an assurance that we are going to pass this special act by two-thirds of majority. And on that basis, Supreme Court allowed them to do so. Thereafter, they came to the Parliament and explained why they are doing it. And at that point, it was very essential, and that is the very reason it was enacted in the Parliament.
Right, so that's a quick look at the history as to how this act came about, and because it was already existing in different countries, we had plans of initiating it in Sri Lanka. So ever since the time it was initiated, or ever since we had this act, tell us a bit about how it has helped the nation.
Yes, now in a situation like that, under normal circumstances, people come and give evidence. The normal people, when they see a criminal act is being done, they are ready to come and give evidence. And it is that evidence is essential, and it is quite enough for the authorities to convict the accused. But in a situation like terrorism is there, then people are afraid of coming to give it. Hardly any evidence to find. To do that, and it is important to keep those people who are involved in this terrorism, so-called terrorism, and the alleged terrorism, then they will be taken into custody, and they will be kept in custody under detention orders. Those are the very important. Under normal law, Sharifa, person will be there for 24 hours or 48 hours, and thereafter he will be produced before the magistrate for him to consider bail or to remand. Here, of course, you can't suddenly produce a person to the magistrate. Instead of that, in the earlier act, it was the authority who is going to decide that they are going to keep that person in detention order. So detention orders are very important at that point, and they kept 18 months as the timeline to keep a person under detention order. So nobody had the power to go there. Lawyers were not allowed to go, and relations were not allowed to see them. And that is why we say it's a tough law and draconian law. So that was very helpful at that point. But I think after the war is over, and we felt that now terrorism is to some extent we were able to control it, and on that basis people were asking to change that or to amend that law, or else abolish that particular law or bring some new law to this particular terrorism. So that is how it was debated later, but at that point in 1979 it was there, and subsequently 83 riots were there. So they have used it for 83 riots, and then 89 riots also. This act was very much helpful to the authority, but the fact remains that when they are going to use it, they have not properly used that only for the terrorism, but in some other cases also, that is when there is a normal case, a normal criminal act was done, they take that person into custody and say that they want to investigate whether there is terrorism involved in that. On that basis, they are not ready to produce that person under normal law. They kept him under Prevention of Terrorism Act. That is a violation of this particular act. That was the issue that they were discussing to amend or abolish. So that was their right through. After 1989 also, the authorities were given the opportunity to change it, but it never happened. Thereafter, in 2015, the Human Rights Commission and Human Rights Organization, they all made a big impact, and then they insisted that there should some amendment or to abolish. So previous government in 2015 October, they pledged before the Human Rights Commission, and they stated that we are going to abolish this particular law. That's how it came into this particular time period, and they have prepared a particular act called Counter-Terrorism Act, 88-page document, but unfortunately that government was not able to present it into parliament, because that party itself says no, it is not proper, and we can't support this particular act. On that basis it was abandoned until last amendment came into power. It was their right through.
So how many times have this act been amended, Mr.
Very few, only two occasions in between, that small amendment. But the original act was there right through till this particular amendment came into power. So that is the main amendment. As far as we can see, the major changes have been done.
And before we talk more about the amendment, if you could also tell us how having a Prevention of Terrorism Act in Sri Lanka helpful internationally? Helpful to our country internationally.
No, it is like this way. Now, if we are in a position to show that we have not violated human rights, and then we have adhered to the strict laws of those terrorism act, then of course people in other countries also, they will realize that we are not doing anything wrong. But unfortunately it was not happening, because we came across a lot of cases where the authorities have taken people unnecessary into custody, and thereafter they kept them for a long period under detention order. So that was the main issue discussed in various forums in foreign countries.
And Mr. De Silva, now let's talk about the recently passed amendments by the Parliament to anti-terror law. Can you take us through the amendments in a
Yes.
layman's point of view so that our viewers will get an
That is,
understanding?
so most of the people, even when I was watching the Parliament debate, I am surprised to see that the opposition party was not gone through those amendments very carefully, because when we were watching that, we thought that they were debating the previous act, that's original act, or the amendments, because they are consistently stating that the people have been in detention for 18 months and nobody can go and see them, all these things. But unfortunately, they have not gone through this latest amendment. Latest amendment was there to amend all these Draconian areas. Those areas were very much addressed in this particular amendment, because now 18 months period have been reduced to 12 months. So you can't say it's a draconian law, because now they have been given the opportunity within 12 months you have to do your investigation and produce person before the magistrate. And in under normal law, a murder case, a person can be kept on remand for 12 months or even 24 months. So it is there in our law. It is not a new thing to our law. But this particular act, there was this 18 months detention order. It has been reduced to 12 months. And the important thing is that a lawyer can go and interview the person concerned and then get all the instruction from him. There is no bar. Earlier it was not available. We saw that Hizbullah's case was argued in Supreme Court. So there, of course, the lawyers has to make submissions before Supreme Court and ask permission to interview the particular suspect. So here, of course, in the section itself says that the lawyer has the authority, and as of right, he can go and get all the necessary instructions from the suspect. And apart from that, the suspect's relatives can go there and then find out what actually happened. And immediately after he was served with the detention orders, it should be informed to the Human Rights Commission as well. There was no such such clause there in the original act. So this is very important. Then if there is something going wrong, then the Human Rights Commission can intervene and see whether there is any illegal acts are being done. And thereafter, another important thing is within 48 hours. Now, the Supreme Court has asked the authorities to change 72 into 48, and within 48 hours, that person should be, the authorities should inform the magistrate about that person. So, it is the duty of the magistrate to visit that person and find out whether there is any torture or threat or any other harmful thing had been done.
In case of human rights violation.
That's right. So then if it is so, the magistrate has the power to inform the JMO and ask the authority to produce that person before the JMO. And once the JMO report is available, he can go through it, and if he sees some wrong things are there, that is any injuries are there, a violation had been done, and then of course it is the duty of the magistrate to inform the IG to get necessary instructions from the Attorney General and file cases against those people who are involved in that. So those things are available on paper. So that is why we say they have done to some extent lot of changes to the earlier act where they call as draconian law. So it is the duty to inform you that you have every right to challenge these detention orders after going to the Supreme Court by way of Supreme Court action. Under section 100, clause under 138, it is very clearly stated that anybody can go before Supreme Court and challenge this detention order. If he is of the view that I have been taken unnecessary, then it can be challenged in Supreme Court. Not only Supreme Court, that now this particular amendment has given power under 140 of the our constitution, that they can get a writ order from the Court of Appeal as well. And habeas corpus application is available. If the parents or the relatives, if they don't know whereabouts of this particular person, they can file a writ application as we call as habeas corpus, and then ask the authority to show where he is at that point. If the magistrate is of the view that he had been not properly questioned or threatened, he had been threatened or tortured, then he can change the place also. That is also available in this particular amendment. So thereafter, the most important thing is restriction of movement. In this particular act, earlier also it was there, they are not implementing it very regularly, because section 11, it is clearly stated restriction of movement. So then they allow that person, if it is being charged for minor terrorism act, or then if they want to investigate more, then they can ask, the authorities can ask them to go out and be with their family, but his restrictions will be his movements will be restricted. So then he can monitor, police can monitor that was available in foreign countries. So that was taken in, and then we are going to have it in this particular new amendment also. And thereafter, the most important thing is advisory board. So advisory board was there earlier act, but it was not functioning. So now the former Chief Justice Asoka de Silva was heading this particular advisory board, and they have gone into, before this amendment came into operation also, this advisory board was appointed. And then this former Chief Justice Asoka de Silva was doing a great service, and he gave permission to release 81 people under detention orders. Unnecessary, they were kept in that detention orders. So he has given power to release them. Before this amendment came into power, in 2021 September, after getting instructions from the Honorable Attorney General, IG has issued a circular to state that the police cannot take a person without any proper material to show that he is involved in that particular terrorism act. So we have, as I told you, we have come across lot of cases where the police wanted to keep that person in custody or the detention orders. They use this Prevention of Terrorism Act, and they go and file the B report to state that we are investigating about this terrorism activities of this particular person, and for that purpose we need time, and please keep him under detention order. So unfortunately, the magistrates also, they are not going through it very carefully. They allow the application, and most of the people were kept on remand for that purpose. From September 2021, even before this act was debated, this was there, this circular was there, and because of that, now the police cannot arrest a person mere for the sake of arresting and show to the court that we need that person. Instead of that, the magistrates also have the power to go through the B report and find out and ask the police what are the evidence available against this person under PTA. If they are not in a position to show that prima facie case is available, evidence is available to charge or to investigate, under PTA, then the magistrate will say, no, I am not allowing your application under PTA. I will remand that person under normal law. If you want, if you have any material, then you bring that material. Thereafter, I will consider. So that is what it is there. So I think the most important area we have to discuss later, that the confession. I am also not in agreement with this particular act. Because of that, this particular area, the confessions are there under this act. It is clearly stated, if you give us confession to ASP or above, the confession can be used as evidence. I think it is not proper. So we will discuss later for future things in this program.
Exactly. So we've got just 3 minutes left on the program, Mr. De Silva. So thank you so much for highlighting about certain amendments and major amendments made to the PTA. And as a final, I just came across a recent article as well where the opposition says the changes will not stop abuses under the law. So your comments on this as a final?
Yes, that's a very important question you have asked, because abusing is the important. The law may be there, that we can't say anything with regard to the particular amendments. But if you are using it in a negative way, if you are abusing that law, it is up to the authorities to do whatever they can do. That is, you can't say the law is not good or not clear. What I say is, if you can remove the part of this confession thing to the ASP or above, instead of that, you can use the magistrate's confession, then it will be a good thing to consider hereafter, and thereafter we can have a new law subsequently to combat terrorism. So government has assured that they are bringing a new law to this parliament. So till such time, it is very important to have this amendment. And if you are in a position, if we are in a position to change that confession part, I think we can say that they have done something important to this particular amendment.
Thank you very much, Mr. U.R. De Silva, for giving us an insight as to what this act is all about, PTA is all about, and how this came about into the country as well.
1 minute.
Yes.
The profession is also saying with regard to bail. So earlier it was not available. You have to get AG's consent for that bail. But now it is very clearly stated in law that you can go to Court of Appeal and ask for bail, and there's after 12 months period, if the case is not being started, then you can ask bail from the High Court as well. And the cases will be heard day-to-day basis. So it will be helpful to a person who is being charged under PTA.
Thank you so much once again, Mr. U.R. De Silva, for highlighting all the major amendments and how it could also bring some justice to the people out there. Thank you very much.
Thank you so much for giving me this opportunity to elaborate what are the new amendments that the government has implemented.
With that, it's time for us to conclude Spotlight this week. Thank you so much for tuning in. Have yourself a pleasant day ahead.
Of us